So welcome to this webinar from the Brodie's Employment and Immigration team. I'm Brian Campbell, a legal director, and I'm joined today by Lynn Marr, who's a partner in the team. And today we'll be looking at the digital or virtual side of tribunal litigation, which of course has become much more prominent in recent months. So let's begin by taking a look at what's been happening and where we are now. So everything goes back to March, of course, with the COVID outbreak and general lockdown restrictions being imposed, and tribunal hearings immediately were postponed. The next month, April, the tribunal presidents for Scotland and England and Wales issued updated guidance to deal with the aftermath of that, and the cloud video platform was launched, the tribunal system's preferred method of delivering virtual hearings. Then fast forward to June, and the presidents issued what they called their roadmap to chart their plan to return to normal tribunal business by the end of this year, which involved first bringing in shorter and simpler cases back online, and then building up to a wider range of hearing types after that. And as a result of that, by August or September, we had hearings in person resuming in tribunal offices up and down the country with suitable precautions in place. So where we are now is that we've got both remote and in-person hearings taking place, where local tier-based restrictions allow, of course. So what does this mean for you if a tribunal claim is made against your organisation and perhaps it might end up on your desk? What should you be thinking about? Well, you'll still be thinking of the usual issues, no doubt, such as how strong or weak is that claim and how much it could be worth, whether the issues in the claim go any wider than the claim itself, and is there any risk to the reputation of your business. But in addition to that, of course, there will be some new issues now to consider. What type of hearing might you get? What would be the best type of hearing for your particular case? And will you even have a say in that? Well, just to deal with the last of those first, as possibly the simplest, generally speaking, you will get a say because, as you may have already noticed, the pro forma tribunal claim and response forms now have an extra question added, which I've attached to the slide, where the parties are given the opportunity to say whether they can take place in a hearing by video. Of course, that doesn't necessarily mean you'll get what you want or you'll get anything at all, but at least you can tell the tribunal if you've got the technology in place. So let's look at those other considerations. What type of hearing might you get and what would be best for your case? We're focusing on the two alternatives being hearings in person in the traditional way and also virtual hearings, entirely virtual hearings. As you may be aware, of course, it's possible to have a hybrid of the two, and where that's relevant, we'll touch on that. So first of all, looking at some factors which the tribunal might consider relevant in deciding which type of claim, which type of hearing to go for. And these are found in the Tribunal President's Practice Direction and Supplementary Guidance, which we've provided a link to in the slide, so I'll just mention them fairly briefly. The first one is the type of claim itself, of course, whether it's, for example, a simple one or a complex one. Does it involve a small or large number of issues? Would it involve being heard by a judge only or a full panel of three? And related to that, what would be the likely length of the hearing? Virtual hearings are generally found to be more demanding in terms of concentration and stamina on the participants, so they're not quite as suitable for longer cases. Whether the parties are represented is another factor as well. It's perhaps not such a determining one, but generally you're more likely to be given a virtual hearing if the representatives are involved, particularly on the claimant's side. Specifically, a consideration is whether anyone is vulnerable or in need of adjustments, which is fairly self-explanatory. The demands of a virtual hearing may be even greater on certain individuals, such as those with mental impairments, but that consideration might equally point in favour of a virtual hearing, for example, where you have a witness who is isolating because they or someone in their household is in a vulnerable health category. Another consideration is whether the parties have access to technology and the right environment. Again, that largely speaks for itself, and Lynn will say a bit more about that a little later on. And similarly, can parties who have representatives communicate with them outside of times where people are giving evidence on oath? And again, Lynn will touch on that. Can everyone participate in a way that's conducive to a fair hearing, which is very much, of course, a catch-all point that can take in all of the points above and anything else specific to your particular case? And finally, can the tribunal properly assess the evidence put before it? Again, that's quite general, but for example, if some of the evidence is particularly technical or in an unusual format, might that be easier to deal with in person with everyone in the same room? So we move on now to look at some factors that might be specific to you and your case. These might be the ones that you need to think more about. So the first one is what the claimant wants or perhaps doesn't want. Now, a judge may feel obliged to go with what the claimant wants, particularly if they're unrepresented and especially if they would prefer to have a hearing in person rather than one on the CVP. So if that's the case, you may end up, in fact, having very little say in the matter. However, the more important factors may well be on your side of the case, so you should explain them and be heard on that. But if it doesn't matter to you either way, you may even want to make a tactical choice. If the hearing type that you go for is not the type that the claimant wanted, might that, for example, make the case easier to settle with them? The next factor that we think is relevant is the effect of timing of the hearing. A hearing in person will probably be listed a little bit further ahead than one that's being conducted virtually. And usually, of course, that works in an employer's favour, since early resolution becomes more attractive to a claimant compared to a wait of perhaps many months for a judgment and then a little bit longer for payment of any award. But there might be circumstances where you prefer to have a hearing take place earlier. Maybe you just want to have it resolved one way or the other, especially if you think that your case is a strong one. Or you may want to take the financial hit that you've become resigned to in a weaker case sooner rather than later, perhaps for budgeting or reporting reasons. And also, of course, for any organisation, employees come and go. So the longer you wait, the greater the chance that maybe one of your key witnesses leaves. Perhaps you've had a restructure or something like that. And so the individual is not so invested in the claim if they're available to you at all. The next point we think is relevant is what best suits your witnesses, and this is perhaps the most important, or one of the most important of all. It's going to be one of the biggest factors, we think, and the answer will vary inevitably from person to person and case to case. So there can be positives and negatives for witnesses in participating virtually. They may, for example, save time and expense by giving evidence from home, and they may feel more at ease through being in a familiar environment. And cross-examination may be less daunting for them, where the person asking them those questions isn't right there in the room with them. And they'll avoid the background health risk and perhaps the general stress of travelling to and from the tribunal office. But however, they may not be so comfortable with the additional layer of technology involved or the perceived sense of distance from a representative who is supporting them or a colleague such as you. So they may not be lucky enough to have a peaceful, secure space with adequate technology at their disposal. So from your viewpoint as a coordinator of a case and the supporter of these individuals, it may be less easy to communicate with them outside of the time when they're on oath, and it may be harder to spot when they're under stress or maybe just fatigued and needing a bit of a break. So it may also be more difficult and time consuming to cover some technical areas of evidence with a witness, meaning an increased need for breaks and a longer hearing. So you'll need to consider all of these factors, the ones that apply to each of your witnesses, and trying to form a view as to which type of hearing might be best for your case. The nature of the evidence and the issues as well, although this is a matter for the tribunal, you'll need to think about it as well. So what type of claims are being made and how long is the hearing going to last? But also consider, for example, is your case one of those ones where the parties essentially agree on what the relevant facts and the documents are, but they just want the tribunal to tell the parties who is right? Or conversely, there are lots of conflicting accounts of events and facts and what relevant documents should be? Because if it's the latter, then questions of witness credibility may come into the reckoning. And if you think you're stronger than your opponent on that front, you may be keener to have them come under the eye of the judge in person rather than just interacting from a distance. But of course, if the opposite holds true and you're concerned about how your witnesses may perform, you'll need to consider that as well. And the final point that we want to mention under this heading is publicity and the principle of open justice. This goes back to really whether there might be any wider issues that are created by the case and any reputational factors for you. Because tribunal hearings have always been open to the public, but generally the logistics of attending a hearing have tended to be a barrier to people doing that. But with a virtual hearing, you can just call up the tribunal office a day or so before the hearing and ask one of the clerks to go through the list of cases with you, and then choose one to be given access to. And you can request the documents be made available to you as well to view if there's a virtual bundle or witness statements. So people's rights haven't really changed in that sense, but they're a lot more easy and convenient to exercise now. So if you have particular sensitivities about how the case could affect your reputation, then this is worth thinking about. And also think about what you're asking of your witnesses. You're perhaps putting them more in the public eye as well in terms of what you require them to do as a performance. And although any person given access to a hearing would be sternly warned not to make a recording of the proceedings or share any of the documents, that relies on them obeying the rules. So moving on then, what happens if you don't get the type of hearing that you want? Well, the first question is, when will a decision be made at all? There may be different answers to that. It could be made by a judge with or without your input, or you may be asked to give your comments in writing, or you may have the chance to give your comments verbally to a judge at a case management preliminary hearing, if there's going to be one. It really depends on the nature of the case, but you'll tend to find that in the simpler cases, there might not be a preliminary hearing and you don't get that very, very valuable opportunity. Whichever it is, though, we hope it's clear to you that it will be early in the process, which means that you have to get early yourself. And really, I think that's one of the key messages we're trying to get across here. All of these things you will need to grapple with and think about very early in the process to make sure that you get things right, you have the best chance of getting the type of hearing that's appropriate to the case, and particularly any concerns or limitations or needs of your witnesses are taken into account. And even if that means getting in touch with the tribunal to ask them whether or how they're going to deal with the question, it may be worth doing that at an early stage to make sure that you don't miss the opportunity. Now, can you challenge the decision to fix either type of hearing if you don't like it? Well, the decision is highly discretionary, so it's very difficult to show that it's actually wrong. You can ask for it to be varied or set aside, but you would have to show that it's in the interest of justice to do that. And that's going to be quite a high bar to clear, especially if you've had the chance to give your reasons already. But if you haven't, it may well be possible to go back and say, here are some considerations that weren't available to the judge when deciding the type of hearing that we're having. We think these are important and we think they're relevant to our position, which is it should be a different type of hearing that we actually have in this case. You can appeal a judge's decision to the Employment Appeal Tribunal, but that will be expensive, and frankly, the chances are slim. So it's really more of a tactical last throw of the dice than anything else. And so if you are stuck with a hearing that might cause you some difficulty, what can you do? Well, your best course of action might just be to accept the decision, perhaps not give your opponent any indication that it is so much of an issue to you, and consider whether you want to prioritise early settlement a little bit more than you were prepared to do. Now, if it's a hearing in person which has been fixed and that's what causes you problems, you should also consider whether there might be grounds to have certain witnesses give their evidence remotely by way of a hybrid hearing. So the hearing in person takes place, but certain witnesses give their evidence virtually as well. Again, there are pros and cons with that, but it's worth thinking about. Or you may just be able to go back to the tribunal and revisit the issue if circumstances genuinely do change, if things change after the hearing is chosen. For example, a vital witness takes ill or moves out of the country or something like that. So you may get a second bite of the cherry if circumstances change. Now I'm going to hand over to Lynn now, who's going to take us forward in the process and focus more on the hearing itself.
Okay, thanks very much, Brian. Well, I'm sure that some of you have already been involved in face-to-face hearings, and a lot of the sort of things that I'm going to talk about are really just the same, actually, as might come up in CDP hearings. But with CDP hearings, there's a lot more practical issues that we really need to think about, whether you're attending in the capacity as an observer or whether you're actually going to be appearing as a witness. So if there is going to be a CVP hearing, then there are some additional things that you want to think about. You obviously on the day want to be able to put forward your organisation's case as best as you possibly can. And that does mean that you want your witnesses to be well prepared. You want them to be able to put their best foot forward first. So you really want to make sure that they are comfortable and that they understand what the process entails in exactly the same way that you would if they were actually attending a face-to-face hearing. You want them to be as confident as they can be. So I'm going to cover quite a lot of things that might seem really obvious, but I'm not going to apologise for that, because they're things that I think certainly some of my colleagues and others that we've heard from have probably learned over the last several months, as I say a few months, but since we've been in lockdown since March and we've been doing CVP hearings, there are some things that have come up through trial and error that it's really useful, I think, to draw to your attention, whether you're attending as an observer or as a witness. And first and foremost, or perhaps the most important one, is technology. Brian's already mentioned that obviously witnesses will have to have access to the right technology, and that is critical. As advisors, it's really incumbent on us to make sure that our witnesses will have access to the right technology. So what is needed? Well, anyone that is appearing to give evidence or is going to be speaking is going to have an appropriate device. So that means that they're going to have a laptop or a computer, something that has a camera so that they can be seen, something with an adequate speaker, and also obviously a good microphone. I think that all probably goes without saying. A sufficient number of screens is another thing to think about. I'm not sure about you, but I'm all operating with multiple screens and never know quite where I'm looking. But it's useful to have certainly one screen to be able to see the judge or anybody else that's participating in the hearing. But you might also want to make sure that your witnesses have a screen that they can look at a bundle on. So if they've got an electronic bundle, they will want to have a separate screen to be able to view that on. They might even want a separate screen if, for example, written witness statements are being used. They might want a screen to be able to view those on as well. And they might want a screen, I don't think we're quite getting to 4, but a screen if they have, or another device to be able to communicate with a legal advisor or with each other, obviously not while giving evidence, but at points during the hearing as well. Headphones, I hate headphones because they're not good for the hair, but headphones are a good idea to have for all witnesses giving evidence, because I think what it does tend to do is it helps to drown out background noise. It makes sure that they can be entirely focused and present actually as they're giving evidence. It's much easier to do that. A good stable internet connection is also critical. There is nothing more frustrating than people dropping off calls. I'm sure that we've all had that in lockdown as we've been on all sorts of Zoom calls, Teams meetings and all the rest of it. So it is really frustrating, but equally it must be incredibly stressful if you're giving your evidence as a witness and you keep dropping off. So making sure that your witnesses do have a good stable internet connection is important. Having the right operating system is also pretty critical. The Employment Tribunal's CVP system is really accessed best through Google Chrome, so the Tribunal does recommend that you download that onto your system in order to be able to access the CVP hearings. So making sure that can be downloaded and it is working is also a good idea. And I've already mentioned making sure that they do have some sort of mobile device or an iPad or something like that, so that they can communicate with you if you're there in a supporting role, or with a legal representative as well. So I think that covers all the technology points. Environment, Brian touched on this as well. It's really important that witnesses do have a suitable environment to give their evidence in if they're going to be comfortable and confident in giving their evidence. Lots of people will be doing it simply from home, and I suppose one of the critical things is to make sure they actually have enough space, and a space that's not where they can be uninterrupted. So they'll want to have enough space to be able to lay out any papers if they are using a paper bundle, or to have their laptop and all these screens that they might have in order to be able to participate in the CVP hearing. It's probably not going to be ideal if they're perched on the end of a bed or they're lounging on a sofa, as we've certainly seen some witnesses do. That's not particularly ideal. So make sure they have enough space in their home. The other thing which they should be aware of, and you can probably tell from Brian and I's backgrounds, that it's a bit like Zoom. There's no facility to blur your background in the CVP hearing. So witnesses should be aware of that, or you should be aware of that if you're going to be on screen at any point during the hearing. So you will want to consider privacy, confidentiality, and those sorts of factors. So if your witness is likely to have a bookcase behind them with work documents or confidential information, or simply stuff that they consider to be private and they don't want on screen, then tell them to remove it and try and have a tidy background going on behind them as well. It will be good if they are also free from disruption. We know that during lockdown, that's not always been possible. People have cats and dogs and children and all the rest of it. But insofar as they can possibly make sure that they are in a quiet space where no one's going to interrupt them, that will be much better. And if there are others in the house, then try and make sure that your witnesses know to ask them not to maybe use the Wi-Fi at the same time, or not to be gaming on their new PS5s in the background. That is probably going to be really helpful. My husband assures me that he does not play games, but sometimes my Wi-Fi goes at the most inopportune moments. So check that out as well. If the environment is not suitable, or you don't think it's going to be suitable for your witness to be able to give their best evidence, then it really is worthwhile thinking about that in advance and thinking about where else they might be able to give their evidence from. It might be possible for them to go into your office space if you've got that and it's safe for them to do it. Or alternatively, it might be possible to get your legal representative to try and facilitate some sort of office space where they are, that they can go in and give their evidence from there. If that's going to help them, then hopefully that should be possible. Okay, moving on to preparation before the hearing. Again, always important, even in hearings which are face-to-face. But with CVP hearings, there's a few more things just to think about in advance. The first thing that I've got up there are bundles. We're all getting to grips with using electronic bundles. They put the fear of God in me. But if you are using an electronic one, does your witness have it? And are they able to move around it properly on screen? Because they'll need to be able to move and get to documents, keeping up with the panel members as well in the actual hearing. If the papers are in paper form, so if the bundle has been sent to their house, have they got it in good time? And is it an unmarked copy? Because the witnesses will be asked by the judge at the start of the hearing whether their copy that they've got remains unmarked. I'm sure there will be an incredible temptation for witnesses just to put on a few little notes or to put in some post-it notes to help them. But that rule remains. They're not allowed to have their own marked up copy, so that their bundle has to be a clean one. It has to be unmarked. Testing technology. I think this is probably one of the most important things. Just sort of say to people, test in advance. There is a link which is provided by the Employment Tribunal Service, so that anybody who wants to access a hearing can test the site to make sure that they can get into it, that they know what it looks like, and that they can get their way around it, if you like. And that you do get that in advance. So make sure, if you're in a supporting capacity, that your witnesses have done that and they know how to get into the tribunal system. Checking camera position and lighting. I know that if you're on screen or your witnesses are on screen, they're not, making some sort of blockbuster movie, but it can be really distracting if the background lighting's not right, if the witness is appearing really dark or really light, or if they're really far down the screen or to the left or to the right. So actually, when they're testing all their systems, it's good to be able to check all these things in advance, so that, again, they can be confident that everyone can hear them properly, see them properly, and their evidence is going to come across much better on screen. If they're using a work system, make sure that the CVP system can be accessed through your work system. Not everybody is able to do that, and you don't want to find that out on the day either. Even people that sometimes tested the CVP system or the link that's come from the tribunal find very close to the hearing, for example, on a Friday night, that it's not working or that they can't access it through their work system. So do check all that as well in advance. And keeping joining instructions handy, pinned to a screen or a post-it note or something, is a really good idea, because with the best will in the world, connections are lost. Even if you've checked your stable internet connection, you might lose it, and you want to be able to join back in as quickly as you can without getting flustered and stressed. Check everything is charged and capable of being plugged in, but that's maybe just me, because I lose count of the amount of times I go to do something and find I don't have any charge. And actually, just picking up on something that Brian mentioned about public hearings and the principle of open justice, witnesses, we will often say to witnesses who are involved in face-to-face hearings that if they can possibly get a chance to do it before the hearing, they should go along to a hearing centre and actually just try and get a bit of an opportunity to watch a hearing. That's actually even easier to do now, because previously, obviously, witnesses just might not have been able to find time to do that, but most people can probably find time in their work schedule now, sitting at their desk, to get a dial-in number and log into a hearing and just watch what's going on in advance. So do encourage witnesses to do that so that they can see in advance what they'll be subjected to. The hearing itself is hopefully quite straightforward, because if you've gotten in, I think after that hopefully gets a bit easier. But witnesses and observers can obviously join early, and it's a good idea to do that in the same way that you would turn up at a tribunal early, just to check out any last minute issues that you might have with technology. Anybody that's going to be on screen needs to remember that it is still a formal hearing, so all the same rules about appropriate attire apply, and switching off all devices and notifications on your devices is a good idea. There's probably, again, if you're a witness, nothing more distracting than seeing lots of little notifications pinging up on your screen, so try and turn off everything where possible. Others present in the room should not be able to guide or influence evidence in any way at all, and that's something that I think we're all mindful of as legal representatives, as to whether somebody might be in a room guiding or influencing a witness. So witnesses should be reminded that can't happen. And some of the other rules that would apply today, face-to-face hearing, just still apply. So in advance, you will want to encourage your witnesses that when they're on screen giving their evidence, they should speak slowly, not perhaps just because the judge is maybe writing down what they're saying, but there can be a bit of a time lag, and there's not the same degree of being able to, you can't interpret visual cues so easily. So it's important to speak slowly and speak into the camera as much as your witness possibly can, and trying to remain neutral, trying not to move around too much, because sometimes the camera might find it difficult to keep up with you, and that causes also a little bit of a distraction. Brian mentioned the fact that CVP hearings can be really tiring for witnesses as well. So if breaks are needed, and there probably will be regular breaks anyway, but if they are needed, then witnesses can still ask for one. They should still have their glass of water to hand as normal. Unfortunately, there'll not be a clerk there making sure there's water on your desk for you, so make sure that you've got your own one to hand. And all parties, again, there might be a bit of a temptation to try and communicate with witnesses whilst they're on the stand, if you like, and giving their evidence, because it's not so easy to see it happening. But there must be no communicating with witnesses while they are giving their evidence. And remember that they are still on oath during adjournments in all the usual ways, so you shouldn't be discussing evidence with them if you're there in a supporting role, if they're still actually on oath and you're just in a break. Turning off videos and muting yourself during breaks is also pretty key. I've heard stories of that not happening, and panel members and the like being heard saying derogatory things in the background. So make sure that you do that. And finally, just making sure that all channels of communication are agreed. In the normal course of a tribunal, all the parties involved, so whether it's your legal representative, whoever's there in a supporting role, and witnesses, might want to have a chat about the case before the day's proceedings start, or at the end of the day to debrief. And you'll want to have means to do that as well, so that you can make sure that after your witness has given their evidence, they're happy with the evidence that they gave. So that's really all I was going to say. Apart from, I think that we now know, whereas I'm sure everyone's delighted to hear about the vaccine that is due to be rolled out next week, but that certainly doesn't mean that we're going to be back to face-to-face employment tribunal hearings before Christmas, or even any time after Christmas. I don't think. Certainly I think all employment lawyers see that CVP hearings, digital hearings, are really something that is going to be part of the employment tribunal landscape going forward now. We have all, at least I think we're getting to grips with it, and certainly it seems to be delivering a lot of benefits, including some of the ones that Brian mentioned earlier. So we do think that we are going to see a lot more CVP hearings going forward, and so it's probably useful to get used to them now, and used to some of the slightly different things that come up in CVP hearings than face-to-face hearings. Okay, I don't know
Thanks
if you've
very
been
much.
watching questions, Brian.
Yes, thanks very much, Lynn. We've got some questions come in, so we'll maybe just try and fit a couple in. So we've had one that says, can a claimant or a witness have someone in the room with them? Now, we've perhaps touched on this, but basically, the simple answer is yes, with permission, because you can only have somebody in the room with you if you're giving evidence, if you've got the judge's permission to do that. And what we're seeing is that judges are asking the parties at the beginning of a hearing or each day, are you alone in the room or have you anyone with you, just to make sure that that's taken care of. Now, with permission, a claimant or a witness could have somebody there really just to think for support. So the individual wouldn't be able to guide them or influence them in terms of the evidence that they give. And of course, that couldn't be a person that would be giving evidence later on in the hearing. That sort of person should be staying well clear if there happen to be two people in the same household, for example, who are both witnesses in the same case. But other than that, an individual could be present with permission. They would be subject to the usual warnings, if you like, that they weren't allowed to discuss the witness's evidence while the witness remained on oath. So during a break or even overnight, there couldn't be any discussion about the evidence in the case until the person had finished giving their evidence. But subject to that, the answer is yes.
Great. I don't know if we've got any time for more questions at the moment. I think we've probably reached our time limit. I can see a few more, and I wonder if the best thing to do is to follow up after the session with those people.
Let's do that. Okay, on that basis then, thank you very much for attending, and for those of you watching back at a later date, good afternoon.